दोस्तों इस क्लास में आपको डिक्टेशन दूंगा मैं 100 WPM पर 600 वर्ड्स की डिक्टेशन है, आपको डिक्टेशन में प्रोवाइड कर रहा हूं। बी रेडी फॉर इट। These appeals have been filed against the common judgment of the High Court of Judicature at Madras in writ petition number 8377 of 2020. The division bench of the High Court by the impugned judgment has allowed the writ petition. The state of Tamil Nadu, aggrieved by the impugned judgment, has come up in these appeals. Two senior Muslim advocates, as referred above, were nominated by the state government in exercise of power of the Waqf Act 1995. One Muslim member of parliament and two Muslim members of state legislature were elected members. The nomination of two senior Muslim advocates was challenged before the High Court by a writ petition which was dismissed upholding the nomination. The state government issued a notification in exercise of power under section 99 of the Waqf Act 1995 superseding the board. The notification was issued after issuance of show cause notice to the 10 members of board existing at that time. The membership of a member of parliament ceased in May 2019, reducing number of members as 10. The state government was of the opinion that two senior advocates who were nominated as members under section 14 proviso cannot be treated as elected members, hence the number of elected members are less than nominated members. Resultantly, the board is unable to perform its work as per the Waqf Act 1995. The period of board was further extended by another 6 months by an order. The process for reconstituting the board was already initiated. Writ petition number 7661 of 2020 was filed challenging the order. The writ petition was dismissed by a learned single judge of the High Court vide its judgment upholding the process of election initiated by order. Writ petition number 8377 of 2020 was filed questioning the order superseding the board as well as the order. The respondent filed writ petition number 726 of 2020 challenging the government order by way of public interest litigation, in which writ petition and interim order was passed by the High Court to the effect that any action taken during the interregnum shall be subject to the result of the writ petition. All the writ petitions were decided by the High Court by the common judgment. Although the High Court held that suppression was not in accordance with law, however, the said order was set aside insofar as the election of two persons. As per the election program, the date of polling was fixed. The schedule of dates for various stages of election to constitute the Tamil Nadu Waqf Board was published in the Tamil Nadu Government Gazette. The High Court, by the impugned order, had quashed the order dated insofar as two members of the board are concerned. Process for nominating other members of the board was untouched and was completed. In May 2019, the number of elected members became 4 with 6 nominated members, making the board unable to perform its functions. Therefore, in exercise of power under Section 99 of Act 1995, the board was superseded. The state government has rightly exercised the power under Section 99 and the government formed the opinion that the board is unable to perform, hence the supersession was ordered. The supersession was extended by subsequent notification. The division bench committed error in setting aside the notification partially. There can be no partial setting aside of the supersession order. The validity of the supersession order was upheld by the High Court in writ petition number 2041 of 2019 vide its judgment. It is not disputed that there are only 10 members in the board at the relevant time after member of parliament demitted office. दोस्तों इसी के साथ ही डिक्टेशन फिनिश होती है। उम्मीद पूरी है आप लोगों ने इसे अच्छे से लिखा होगा। मेहनत लगातार करते रहिए। आपसे मुलाकात करूंगा अगली क्लास में अगली ट्रांसक्रिप्शन के साथ। तब तक के लिए बाय बाय, टेक केयर।